India Legal presents Courts Roundup.
Hello, I'm Hishay and you're watching Courts Roundup. In this program, we bring you the latest legal news and details of court proceeding. And before we begin, here's the headlines. Supreme Court stays Election Commission's order revoking Kamal Nath's star campaigner status in Madhya Pradesh by polls questions Election Commission's power. Supreme Court issues notice in a plea seeking investigation by the CBI and ED in Westland Trade Private Limited scam. Offences include money laundering and black money hoarding. In Delhi riot case, Kakaduma Court orders police to give accused a hard copy of Chargesheet, says soft copy not enough under CrPC. And Supreme Court declines to provide cover to Judge Surender Yadav, who had delivered the Babri Masjid demolition verdict acquitting Advani, Joshi and others.
India Legal presents Courts Roundup.
The Supreme Court has stayed the Election Commission of India's order revoking senior Madhya Pradesh Congress leader Kamal Nath's star campaigner status in the upcoming by-poll in the state. A three-judge bench headed by Chief Justice of India S.A. Bobde questioned the poll body over its decision. Where does EC have the power to determine who will be the leader of a party under Section 77 of Representation of People's Act? The bench asked. The Supreme Court has stayed the 30th of October order of the Election Commission of India delisting former Madhya Pradesh Chief Minister Kamal Nath as the star campaigner for the upcoming by-election in the state. The bench of Chief Justice of India S.A. Bobde, A.S. Bhopana and V. Ramasubramanian pulled up the ECI for exceeding its power by passing the order. Senior advocate Rakesh Dwivedi, appearing for this ECI, submitted that the matter is infructuous now, as the campaign is over and the polls are slated to be held tomorrow. However, CJI said, "We are staying your order. Who has given the power to you? Delist a candidate from being a star campaigner or a leader of the party under Section 77 of the Act. We have read it." When Dwivedi urged the court to not stay the order and instead call for a reply from the ECI, the bench refused to agree. It stated that the ECI will have to reply and that the order will be stayed pending further orders. Senior advocate Kapil Sibal, appearing for Kamal Nath, submitted that ECI order was passed arbitrarily as no notice was issued to Nath for it. In its order, the ECI has stated that Nath's star campaigner status was being revoked for repeated violation of Model Code of Conduct and for complete disregard of warnings issued to him. According to ECI, Nath, being a leader of a political party, had repeatedly breached ethical and dignified behavior. Kamal Nath had earlier been warned by the Election Commission after he used the word item for a woman Bharatiya Janata Party candidate who is a former Congress leader and among the 22 MLAs whose exit led to collapse of his government in March. Campaigning in Dabra, he had mocked BJP's Imarti Devi, saying that the Congress candidate was a simple person unlike his rival who was an item. In his plea, Nath states that the ECI had already passed an order on October 26th on the same complaint by the BJP and had advised the Congress leader to not use such word. However, pushing him again through the October 30th order is completely in teeth of principles of fair play and res judicate, he claimed. The plea filed by advocate on record KVC law officers and drafted by advocate Varun K. Chopra and Gurtejpal Singh states that the 30th October order of the poll body is illegal, arbitrary and unreasoned. The petition goes on to allege that leaders of the BJP have been repeatedly making statements ex face in violation of Model Code of Conduct during the period of campaigning for the by-election. However, no such action has been taken against such persons by the ECI, says Kamal Nath in his plea. Kamal Nath has further claimed that the Election Commission did not issue any notice to him before passing the order to take away his star campaigner status. Bureau Report. The Supreme Court today dismissed a petition filed by Sarita S. Nair as frivolous and also imposed a cost of 1 lakh rupees. Nair, an accused in the solar scam, had challenged the election of Congress leader Rahul Gandhi from the Wayanad constituency. "We are going to impose cost on you for this frivolous case," said CJI S.A. Bobde. The other judges on the bench were Justice A.S. Bhopana and V. Ramasubramaniam. The Supreme Court has dismissed a petition challenging the election of Congress leader Rahul Gandhi from Kerala's Wayanad constituency in the 2019 Lok Sabha polls. A 3-judge bench headed by Chief Justice of India S.A. Bobde also imposed cost of 1 lakh rupees on petitioner Sarita Nair for filing frivolous petition. The case was an appeal by Nair against the October 31, 2019 decision of the Kerala High Court by which her election petition challenging the Lok Sabha poll in Wayanad and Ernakulam were dismissed. The petitioner's nomination paper for contesting Lok Sabha polls from Wayanad and Ernakulam Lok Sabha seat were rejected by the returning officer in 2019 on account of her conviction and sentencing in 2 criminal cases related to the solar scam in the state. The Kerala government had not allowed the petitioner's plea challenging the polls in both Lok Sabha seats, stating that her nomination papers were rejected as the conviction in the 2 criminal cases had not been suspended. The High Court had observed that only the sentences in the cases were suspended by the appellate court. Gandhi had won Kerala's Wayanad seat, the second seat he contested in 2019 polls, with a record margin of 4,31,770 votes. He had defeated his nearest rival PP Sunair of the Communist Party of India, who secured 2,74,597 votes, while Gandhi got 7,06,367 votes. As per Section 8 of 3 of Representation of People's Act, the returning officer can reject the nomination of a candidate if he or she is punishable in any criminal case for more than 2 years. Sarita was convicted in the solar scam with a Perumbavoor first-class magistrate court sentencing her to 3 years imprisonment and imposing a penalty of 10,000 rupees. In another case, Pathanamthitta Judicial First-Class Magistrate Court imposed a fine of 45 lakh rupees fine on her. The returning officer had rejected her nomination to contest from Wayanad Lok Sabha constituency, citing her conviction. Bureau Report. As the Supreme Court sat to discuss the issue of a Madhya Pradesh High Court judge allegedly trivializing the condition of bail to a molester, Attorney General K.K. Venugopal told the bench of Justices A.M. Khanvilkar, Dinesh Maheshwari and Sanjeev Khanna that there is need to educate judges on gender sensitization. He said the High Court judge seemed to have been carried away as this order was nothing less than a drama that must be condemned. The High Court judge had asked a molester to tie a rakhi on the victim and promised to protect her. That was the condition for bail and this decision was challenged. This has become a pivotal case and the Supreme Court will consider guidelines for judges in this regard on November 27. The discussion on permissible condition which can be imposed while granting bail were on today. The AG's comment came on a petition by lawyer Arpana Bhatt and who pointed out similar orders by high courts across the country. A plea against this particular high court judge's order was brought by 9 lawyers. The plea states that such orders objectify women and is a gross trivialization of the trauma suffered by the victim. The public-spirited lawyer led by Arpana Bhatt had submitted that imposing a condition where the accused would be required to go to the house of the complainant on the festival of the Raksha Bandhan and request her to tie a rakhi around her wrist and the promise to protect her to the best of his ability for all times to come, resulted in further victimization of the survivor in her own house. The Supreme Court bench of Chief Justice S.A. Bobde and Justices A.S. Bhopana and V. Ramasubramaniam heard a plea filed by Arnav Goswami, editor-in-chief of Republic Media Network, challenging the breach of privilege motion against him by Maharashtra State Legislative Assembly. The motion was moved against Goswami by Shiv Sena MLA Pratap Sarnaik, accusing Goswami of using derogatory language against Chief Minister Uddhav Thackeray and NCP President Sharad Pawar in relation to the alleged inaction by the state government in the case pertaining to the death of actor Sushant Singh Rajput. The counsel appearing for Arnav Goswami stated that the act does not constitute breach of privilege. On being asked why reply was not filed, the counsel informed the court that they could not file the reply because the Privileges Committee was not constituted at that time. However, the court denied the argument and said that it is not a privilege question yet. The matter is listed for next hearing on Friday, and the bench has further asked Goswami to file an affidavit. Earlier on October 26, the Apex Court had asked the Republic Media Network to file an affidavit on the series of vindicative and vendetta-driven action of the Maharashtra government. A bench led by Chief Justice of India S.A. Bobde had directed the transfer of all pending petitions concerning financial assistance for lawyers affected during the COVID-19 lockdown to the Supreme Court. Earlier, while hearing the suo motu case on providing financial aid to lawyers amid the COVID-19 pandemic, the Supreme Court had wondered how real, deserving and unfortunate lawyers could be identified so as to avail any financial aid scheme. CJI Bobde noted that the Madras High Court has disposed of a plea pending before it on the issue, adding that the office report also indicates this. However, the Bar Council of India Chairman Advocate Manan Mishra accused Dr. A.E. Chelia, the petitioner before the Madras High Court, of misleading the court. The Supreme Court had now directed that the case pending in Madras High Court also be transferred to the Supreme Court, and the bench of CJI Bobde and Justice A.S. Bhopana and V. Subramanian had earlier noted that all the High Court Bar Association have suggested that the centre develop a contingency fund from which interest-free loans can be given to struggling lawyers. The bench further noted that the power structure would lead to the exclusion of the real deserving lawyers. While asking senior advocate Shekhar Nafade to help the bench in identifying such members, CJI Bobde said, the Supreme Court has issued notice in a plea-seeking investigation by the Central Bureau of Investigation Enforcement Directorate and SFIO, or Serious Fraud Investigation Officer, by a special investigation team into various offences, including money laundering and black money hoarding, by directors and beneficiaries of Westland Trade Private Limited. A bench comprising of Chief Justice of India S.A. Bobde, Justices A.S. Bhopana and V. Subramanian has issued notice to Home Ministry, Finance Ministry, CBI, ED, SFIO, Police Commissioner of Delhi, Gurugram and Noida. Senior Advocate Gopal Shankar Narayan appeared for the petitioners and submitted that despite complaints, no action was being taken. Only one FIR registered in Noida, and this issue is of a national nature. State nor central agency taking action, said the senior counsel. The plea has been filed by 38 petitioners through Advocate Ashwini Upadhyay, averring a franchisee scam, and states that the directors of the company, in collusion with ROC and bank staff, registered many fake, bogus and ghost companies and brands. Additionally, the petitioners have also prayed for appointment of a receiver or forensic auditor. and pass appropriate direction for recovery of petitioners' hard-earned money expeditiously, and also to direct Centre to take opposite step to prevent such frauds in future. And we are now joined by Advocate Shivam Sharma for more update on this.
Yes, in this case, the plea states that the injury is large because under a well-planned conspiracy, directors, meeting partners and employees deceived by the petitioner by fraudulently and dishonestly including them to deliver their hard-earned money, thereby causing injury to not only mind, body and property, but also to right to life, liberty and dignity, and shadow guaranteed under Article 19 and 21 of the Constitution. The petitioner in this area also claimed that the instant case is not a simple case of mischief, forgery, criminal breach of trust, dishonesty, indulging delivery of property, cheating by personation, falsification of accounts, concealment of property, dishonest misappropriation, corporate fraud, dynamic transaction and black money, but the biggest franchisee scam of India. Therefore, the Supreme Court issued notice to Home Ministry, Finance Ministry, CBI, ED, SFIO, Police Commissioner of Delhi, Gurugram and Noida. Yes.
Thank you, Shivam, for the update. A Kakaduma Court has ordered the Delhi police to give those accused in the Delhi riot case a hard copy of the charge sheet filed in the matter, rejecting submission by the state and that its provision of the charge sheet's soft copy on a pen drive to the accused was sufficient compliance of Section 207 of the CrPC. Judge Amitav Rawat said the court directs that the investigating agency shall provide the physical copy of charge sheet and accompanying documents to every accused person by next date without fail. The court went on to rule thus the investigating agency is duty bound to supply hard copy to the charge sheet with accompanying documents to the accused, and the soft copy is a copy made available for the benefit of the accused counsel accordingly. The court also cannot ask for supply of soft copies in the particular manner which is more comfortable of handy to him. The judge also reasoned there is a provision in the CrPC that if any document is voluminous, and then instead of furnishing a copy thereof, the court can direct and that he be allowed to inspect it either personally or through pleader in the court. This provision indicates that hard copy has to be supplied, as this proviso would not apply to soft copy, whereas the state submitted that it required 15 days time to obtain sanction for funds from the Delhi government to provide hard copies of the charge sheet for all accused. Judge Rawat responded. And the Patiala House Court has directed the search engine giant Google and social media site Facebook to block the alleged defamatory videos posted against Modi Care Limited, a direct selling company. The order was passed by senior civil judge cum rent controller Vikrant Vaid, who granted this relief to Modi Care and restrained Ramila Rana, a former consultant for the plaintiff Modi Care and now working with one of the plaintiff's competitors, from making any unverified, unsubstantiated and ex facie defamatory statement concerning the plaintiff, or repeating or republishing the statements made in the video forming the subject matter of the suit. And also the court has restrained a person named Satyapal Singh, who runs a YouTube channel called Satya Hunk and who is a self-proclaimed journalist, from posting any defamatory content against the plaintiff. Notably, Ramila Rana allegedly posted contents which were extremely defamatory, and the plaintiff on her Facebook page and YouTube channel. It was also averred that this false statement had a direct and severe impact on the reputation of the plaintiff as an employer. The allegation including that the plaintiff has been involved in scamming and misleading person to join the plaintiff company. The Supreme Court has refused to extend security to former Special Court Judge Surender Yadav, who had delivered the verdict in the 28-year-old Babri demolition case in September, and all 32 accused in the high-profile case, including BJP's founder member L.K. Advani and Murali Manohar Joshi, were acquitted on September 30th by a special court in Uttar Pradesh, Lucknow. Supreme Court has rejected a request by the retired judge Justice S.K. Yadav, who recently acquitted all 32 accused in the Babri Masjid demolition case, of extending his security over the sensitive nature of the case he handled. Former Special Judge S.K. Yadav had recently pronounced the verdict in the Babri Masjid demolition case and acquitted all 32 accused, including BJP veteran L.K. Advani, M.M. Joshi and Uma Bharti. A Supreme Court bench headed by Justice R.F. Nariman and also comprising Justices Navin Sinha and Krishna Murari was considering the former judge's request to continue his personal security in view of sensitivity of the case decided by him on his last day in office. The Supreme Court on Monday said, having pursued the latter, we don't consider it appropriate to provide security. Justice Yadav, 60, was to retire in 2019, but he was given extension by the top court to hear the decades-old case which he had been handling since 2015. On his last day in the office, the former judge had delivered the verdict acquitting all the accused. Antisocial elements brought down the structure. The accused leaders tried to stop these people, he said, adding that merely giving a proactive speech was not enough to prove guilt. On September 30th, the special court had acquitted all 32 accused in the case, saying there was no conclusive evidence that they were part of any conspiracy to bring down the disputed structure in Ayodhya. The 16th century mosque was demolished on December 6, 1992, by Kar Sevaks who believed that it occupied a site where Lord Ram was born. The destruction triggering riots that left hundreds dead in the country and widening rifts between the communities. Last year, a 5-judge constitution bench of the apex court had ruled that 2.77 acres land claimed by both Hindus and Muslims would be handed over to a trust for the building of a temple. The top court had also ordered allocation of 5 acres land at another site in Ayodhya for building a mosque. Bureau Report. And that's it for Courts Roundup today. Thank you for tuning in. Keep watching APN for more updates from around the nation.
India Legal presents Courts Roundup.